Good morning, ladies and gentlemen. It's my privilege to moderate this first panel session on convergence in data protection law, where we examine what progress is being made toward common standards, what we could do to accelerate that progress, and any impediments to it. 40 years ago, development was near complete on the first two international data protection agreements, the OECD guidelines and the Council of Europe Convention 108. Both of these instruments responded to a fundamental question with which we still grapple today. How can the flow of personal data between countries be facilitated by common standards for data protection agreed between groups of countries? 40 years later, 136 countries have enacted data privacy laws, whereas back in 1980 there were only 10. And these 136 countries have enacted laws which at least meet and usually exceed the standards set by those 1980s instruments. There have also been further international instruments which deal with this same issue of agreed data protection standards in order to allow flows of personal data. Quite a few of those agreements are regional in areas such as the European Union, West Africa, the African Union, and between APEC economies. Latin American data protection authorities have also developed their own recommended standard at the request of their governments. And the standards in most of these agreements, the data protection standards, have also risen, most notably with the EU's recent General Data Protection Regulation, or GDPR. Now, in my view, these standards, international standards or instruments, fall into two groups. First, there's the OECD, APEC and ASEAN instruments, which have made relatively few changes since the 1980s OECD guidelines. And then on the other hand, there's the Council of Europe, European Union and various African instruments, which have continually and progressively developed considerably higher standards. So this panel addresses a version of this fundamental issue. How can privacy standards be raised around the world so as to create the convergence we're looking for and assist interoperability? We're asking, is the answer to this found in a global agreement, in regional instruments which are interoperable, or in other devices like common contract clauses? So, to address these issues, we have been able to, the conference committee has been able to invite many key regional data protection organisations around the world to each provide a speaker who would outline potential solutions that are most appealing in their region and also note the main impediments that need to be overcome. You see on the slide in front of you the nominated panellists from each of these regional organisations, each of whom is a distinguished member of a data protection regulator. And in addition, we have not up on stage at the moment our commentator, Mark Rotenberg, who's the CEO of one of the world's longest established non-government organisations specialising in privacy issues, EPIC in the USA. You can find the detailed bios of all our speakers on the conference website. Each speaker is going to have 8 minutes to speak, but may well take less to allow time for questions. And I will give them a reminder a yellow card, in fact, after 7 minutes. They'll be focusing on regional and global questions, not so much on their national laws. But now, before we turn to each of our panellists in turn, the instructions the conference committee has given moderators is that we should not be afraid to be provocative. So I'm going to make a few personal observations about obstacles to conversion on higher standards, on which any of our panellists are welcome to comment. So first, adequacy decisions in relation to the EU, from the EU, are slow in arriving. And the first one we've seen under the GDPR has not added as much to our understanding as perhaps we would have liked. So we should ask the question, can the EU work any faster on adequacy decisions? Turning to Convention 108, the existing convention has had moderate success in attracting 8 non-European parties. But now we have the question of how many countries are likely to be able to ratify the modified Convention 108 Plus with its higher standards. If we turn to the OECD guidelines, as I mentioned, they've had relatively little development toward higher standards over the last 40 years. And the APEC framework is somewhat similar to that. Can they lead us into the future? Can they be improved? And APEC's cross-border privacy rules still only have 2 countries that are fully involved in the system, the USA and Japan, and only a very, very small number of companies have been certified under that scheme. So is APEC cross-border privacy rules still alive, or is it going to improve in future? And turning to Africa and Latin America, we can ask, when is the African Union Convention going to obtain enough ratifications to come into force? And is Latin America going to develop a similar binding convention as is occurring in Africa, or is it going to skip that step and rely on Convention 108 Plus as its convergence mechanism? I attended quite an inspiring side event yesterday that indicated to me that that might well be the case, that second path. So it'll be interesting to have some light on that. So that will suffice for my introductory comments, and it's now with great pleasure that I'm going to hand over to our first panellist, Chowki Geddes, who is the head of the Tunisian Data Protection Authority and president of the Francophone Association of Personal Data Protection Authorities. Chowki, over to you.
Thank you. Bien, bonjour tout le monde. Les transparents ne sont pas là, donc je vais faire ça. Je suis désolé. Donc là, on m'a demandé dans ce panel de traiter de la question de la convergence. Et effectivement, c'est comment est-ce qu'on peut aboutir à avoir une convergence autour des normes de protection des données personnelles sur le plan mondial, universel. Je considère en tout cas que cela passe par la mise en réseau des États autour de certaines normes, de certains principes, et que la francophonie est un bon exemple pour cela, puisqu'on a des avancées notables sur ce plan. Je rappellerai tout simplement que la déclaration de Bamako, qui date de l'année 2000, qui est le premier texte de la francophonie relatif aux droits humains et à la démocratie, reconnaît en tout cas un caractère inaliénable de la dignité humaine. Et c'est ce qu'essayent d'appliquer dans leur législation les différents États de la francophonie. Je vous rappelle tout simplement que la francophonie réunit quelques 88 États entre États membres et États observateurs, et que parmi ceux-ci, il y a 62 États qui ont une législation en matière de protection des données personnelles. Et donc c'est un réseau assez développé sur ce plan-là. La dignité humaine, qui est transcrite dans tous les textes et dans la philosophie même qui sous-tend la francophonie, eh bien, est un principe qui permet de se comporter avec l'individu comme étant un être humain et non pas comme un objet. Et le dernier épisode, en tout cas, qu'on a tous eu à remarquer et à étudier, qui est l'affaire Cambridge Analytica, a démontré, en tout cas, aujourd'hui dans le monde, que les êtres humains sont plutôt utilisés comme étant des données, comme étant des objets, et ceci fait fi à toutes les règles qui sous-tendent le principe de la dignité humaine. Autre chose, les développements technologiques, le big data, l'intelligence artificielle, chaque fois que l'on traite de ces questions-là, effectivement, cela pose la question de savoir on traite qui, on traite quoi exactement, et est-ce que derrière, ce n'est pas une confirmation de ce qu'on a toujours affirmé quelque part? Si c'est gratuit, c'est que le produit, c'est vous, et si vous êtes un produit, c'est qu'on a nié votre dignité en tant qu'être humain. Donc, la déclaration de Bamako, qui insiste sur la préservation de la dignité des êtres humains, pose la problématique en ce qui concerne la protection des données, la question de la patrimonialisation des données personnelles. Est-ce que les données personnelles sont un bien ou est-ce qu'elles sont ou elles font partie de l'être humain lui-même? Et à ce titre, elles doivent être protégées comme telles. Dans l'espace francophone, on est arrivé à un consensus sur cette question et dans le cadre de l'Association francophone des autorités de protection des données personnelles, l'année dernière à Paris, au cours de l'Assemblée générale, on a édicté une résolution spécifique sur la propriété sur les données personnelles. Et dans cette déclaration qui a été présentée au cours de la 40e conférence internationale des protecteurs des données à Bruxelles, la déclaration dit, ou la résolution déclare, que les données à caractère personnel sont des éléments constitutifs de la personne humaine qui disposent dès lors de droits inaliénables sur celle-ci. C'est une résolution qui tend à s'universaliser dans les principes qu'elle préconise et dont on retrouve aussi le fondement dans des normes beaucoup plus larges, initialement dans un espace régional, mais qui s'universalisent. Je parle bien sûr de la Convention 108. La 108+, dans son préambule, déclare, je cite, « Il est nécessaire de garantir l'autonomie personnelle de toute personne, fondée sur le droit de la personne de contrôler ses propres données à caractère personnel et le traitement qui en est fait. » C'est ainsi un cas qui explicite l'affirmation avec laquelle je commençais mon exposé. La convergence doit se faire autour de valeurs communes et dans des réseaux et des espaces pour prétendre par la suite à une certaine universalité. Je vous remercie pour votre attention. You haven't.
Thank you very much, Chauki. We now turn to our second speaker, Bruno Gencarelli, who is the head of the Data Protection Unit in the European Commission. Bruno.
Thank you very much. And maybe let me first also thank our host, the Albanian Data Protection Commissioner's Office. I must say that the way this country and this city is changing, the dynamism we can all feel, the work of the Albania Data Protection Commissioner's Office is extraordinary. And in a certain sense, also following what the Prime Minister said, makes us proud to be European. Going to our topic, one thing is clear. Convergence in privacy is a reality. It's right before our eyes. It's no longer just an interesting and maybe intriguing topic for conferences, articles, or papers. And as shown by your slides, Graham, the evolution, the trajectory, the transformation in the past years has been quite extraordinary in that respect. If you allow me to refer to my personal experience, when I started working on privacy issues 6 or 7 years ago, I would typically hear 3 observations following comments when I was traveling and trying to explain what we were doing in the EU or under GDPR. First, privacy is a sort of European obsession. It's not fit for other system. It's a question of culture, of history, etc. So if you want the sort of cultural relativism or determinism versus universalism. Second observation, nobody cares anymore about privacy. It's an outdated topic in the digital era. Third observation, there's no need for legislation in this area. Industry will figure it out. It's too complex for legislation. Well, certainly you don't need me to tell you that things have changed, including in the public discourse, and have changed dramatically. We're talking of a truly universal value and a truly global trend. From Brazil, which is introducing privacy in its constitution and is setting up, as we speak, its first ever data protection authority, to India, who is considering comprehensive legislation in this area after its Supreme Court ruled that, against the government, ruled that privacy is an essential element of human dignity, from Kenya, which is also legiferating in this field, to Japan, which through its Data Free Flow with Trust initiative seeks to promote, to facilitate data flows between, let's say, like-minded countries that share a common approach in this field. Just to mention a few examples. And what is remarkable is that this is not only a question of numbers, we know that we should be careful with numbers. This is not only about quantitative development, it's also about qualitative ones. These new or modernized data protection laws are increasingly based on a number of common features of shared elements that are also shared, but not only by the European system, such as an overarching legislation rather than sectoral rules, enforceable individual rights, an independent supervisory authority. This is the convergence we are speaking today. It's hard convergence. It's not the one based on vague standard and loose mechanism some might still have in mind. And why is that important? Because this developing convergence offers new opportunities in terms, of course, of enhanced protection of data, especially when data travels around, and at the same time facilitated data exchange and therefore trade, but also cooperation between public authorities, including in the area of law enforcement, and more generally social interaction. At the EU, at the Commission, we are committed and we are engaging very much on these issues, and we are intensifying our engagement with third countries and other international partners, trying to build and further develop elements of convergence between a privacy system. Because we believe that indeed the privacy, convergence in privacy standards pays off. This includes, and you've mentioned, and probably we will come back to that in the question time, but this includes exploring the possibility of adopting adequacy findings with third countries. That's what we have done at the beginning of this year with Japan, creating the world's largest area of free and safe data flows, adequacy negotiation with South Korea at an advanced stage, and exploratory work is ongoing with a view to launching adequacy talks with several Latin American countries. And of course, we are also working at, probably there will be time for that too, we are also working on other tools for transfers, because we believe we need to have a broad toolbox for transfers. The world is diverse, the transfers are diverse, the business models are diverse, the needs are diverse. It's also, in that respect, I want also to mention, since we are in a transitional moment in Europe with a new commission, that this issue of working on convergence is at the very center of the digital agenda of the new commission, European Commission that will take office for the next 5 years. So where do we go from here, since I have 2 minutes and 31 seconds? Well, it's time to bring convergence to the next level. And what do I mean by that? I'm always surprised that at a time where when privacy compliance issues or data security breaches can affect a large number of jurisdictions and a very large number of individuals simultaneously at the same time, there is so little in terms of real instruments, not in terms of nice paper, as regards cooperation and enforcement cooperation between enforcers. I don't understand why we can effectively cooperate between enforcers, I don't know, on the fight against cartels in the area of antitrust, and why similar instruments don't exist in the area of privacy. We have new tools in the EU, including the GDPR gives us new instrument in that field. And we also hope that I experience what we are developing right now in the EU through a much closer cooperation between our enforcers can contribute to that very important international conversation, and that we can develop, as I said, hard convergence in that field too, for real cooperation through the exchange of information on investigation, testimonies, evidence. That's what is needed here. And then the other, I think, new frontier, or where there's certainly more need for convergence, and I will just mention it because there's no time, just as a headline, we need also horizontal convergence. What do I need? What do I mention by that? That privacy is, of course, an integral part of many other policy fields. And I'm thinking, for instance, there's a lot, and there will be a panel on the interplay between privacy and competition, for instance, but an area where there's a desperate need for more privacy, I would say, input and upstream is law enforcement. My colleague from the Council of Europe is there. It's very striking to see that right now, the Council of Europe is rightly so very proud of its Convention 108+. There's another negotiation at the Council of Europe, which is the negotiation on the Budapest Convention and the additional protocol, so the Cybercrime Convention. And we were there last week at the negotiation, and this is about direct access to data from law enforcement authorities to companies. And the privacy element, the need to build strong safeguards, including to ensure that the output, the product of that cooperation is a solid one, that element, unfortunately, is not yet there. Thanks. But I guess we will talk more about this.
Thank you. Thank you. We need to pass along the slide.
Thank you.
It's now my great pleasure to introduce Dr. Felipe Rotondo. He is a member of the Executive Council of Uruguay's Data Protection Authority, and at present Uruguay is the chair of the Ibero-American Network of Data Protection Authorities. Thank you.
Thank you. At first, I'd like to do an aclaración, because I'm going to speak in English, but my language is Castellano, is Español. But my unit, Uruguayan unit, consulted about it and se contestó que debíamos hablar en inglés o en francés. That is the reason. On behalf of the Ibero-American Data Protection Network and of Uruguayan Authority, which is the current law chair, it's a pleasure at first to point out a few words about our network. It includes Portugal, Spain, Andorra, Brazil, and the Spanish-speaking countries in the Americas. Its objectives are to promote institutional cooperation and to foster measures that ensure personal data protection as a fundamental right. The Spanish authority is a permanent secretariat, and the European supervisor and the consultative committee on Convention 108 of the Council of Europe are observers. In June 2017, the network approved standards that serve as a adequate framework for the countries. The GDPR and the Convention 108 have clearly influences in this document. Now, I'm going to mention some facts related to the region. Several countries have good laws and control authorities with powers to ensure compliance. Argentina and Uruguay were considered with adequate level for transfer from the European Union. Now, of course, is the moment to review the situation accordingly to the GDPR. Approaching this regulation, there are news. General and complete laws in Brazil and Panama. Additional rules in Uruguay. Important projects in Chile, Ecuador, and Argentina. In this case, it will change the current law. Uruguay, Mexico, and Argentina acceded to Convention 108. Now is the moment of ratification process of Convention 108+. Chile, Peru, and Mexico integrate Asia-Pacific Cooperation Forum, one perspectives toward another privacy regimes. I'd like now to stand out the following aspects. The respect of principles of data protection is really relevant. There are different mechanisms that could be used isolated or together. For example, accession to Convention 108+ as a global forum, very close cooperation between authorities and beyond them, including all the stakeholders. We have also private good practice that absorbs law, etc. In the matter, it's required an open mind, not reinventing data protection, but of course, fostering effectiveness. Free and safe data flows are needed, and that is vital to promote trust in data protection global system. The Ibero-American network goes firmly in this way. Thank you very much.
Thank you, Felipe, and thank you particularly for easing our time problems. I'll now call on Stephen Wong, who is the Data Protection, the Privacy Commissioner for Personal Data from Hong Kong. And I'd note that in our program, it said that we're paying special attention in this session to the role of China in the data protection world. So I think Stephen's also going to say a few words relating to China. Thank you.
Thank you very much, Chair, for giving me this opportunity to try to explain what has been happening in Hong Kong and hopefully in the mainland of China in relation to the data protection law. It's often said that the law is lagging behind all the time the development of technology. And I will have to recall or remind in the audience the fact that Hong Kong data protection law could be attributed to the OECD guidelines and the EU Directive 95, pretty much model on these two pieces of legislation or directives. It was enacted in about 23 years ago, just before the reunification of Hong Kong and China, and the mainland of China. And the reason why I mentioned Hong Kong and the mainland of China is that we have two different legal systems as well. Apart from social, economic, and political systems, we have two different legal systems within one country. Indeed, in Hong Kong's data protection legislation is one of the oldest in the region or in Asia, but we are mindful of the latest development in technology and the changes or the evolution in the global privacy landscape. So we are proposing legislative reform in order to, in a way, to catch up with the development in the global data protection. The reforms are more or less prompted by one, the changes in the global landscape, in particular, the GDPR, implemented a year ago, and also the recent cases, data breaches cases in particular, in Hong Kong that we investigated, and as Bruno mentioned, whether it is a trend in the sense that it is truly universal or truly a global trend. Okay? So this is something that we have to consider in making our suggestions to change the law. And whether the law should be overarching, as you mentioned again, and or sectoral, as in the case of the mainland of China. So we're talking about global convergence in data protection. So this is a list of possible changes that we are proposing to change our law, existing law in Hong Kong. So you're including expanding the meaning of personal data, so to bring it more in line, with the definition of other jurisdictions, in particular the GDPR, by making it, or removing, the restriction of ascertaining the identity of a particular person. We try to extend it, to mean information that is, for example, capable of identifying a person. And we also tried to impose a mandatory breach notification. Currently, notification is entirely voluntary. So we try to follow the examples of, for example, EU, by making it compulsory for organizations who breached data protection principles to file notices to, number one, the persons affected, and number two, the data protection authorities. The third area of reform relates to the regulation of data processes. Currently, data processes are not directly regulated under the ordinance, and we're trying to make those processes directly under-regulated. And the fourth one is about powers of the commissioner to carry out investigations. This is, of course, in relation to the recent data breaches that we try to investigate within the confines of the legislation. And recently, there are even more reasons to relax or to give us more powers to investigate criminal offenses in relation to the recent unrest, social unrests in Hong Kong involving data. Very briefly, let me explain to you that data has been used as a weapon in Hong Kong to attack opponents holding different opposing or ill-founded views in Hong Kong by posting the personal profiles plus messages often intimidating with incitement, etc., online and offline. So this is a unique and very difficult case for us to investigate. And bear in mind that most of these websites and platforms, forums are not operating in Hong Kong. So we need to have more power to deal with these cases. And accountability principle, will be hopefully be built in our reformed legislation as well.
Just another minute or so, Stephen.
That brings us to the development in the mainland of China. We're talking about sectoral approach, as it often appeared to be in the mainland of China. And sometimes specific, user-specific approach. So we talk about the purpose, the use of the data, and sometimes the data subjects, right? You can see that the children's right is often covered. And in a year's time, hopefully, we have a overarching legislation in the mainland of China, and that is the legislation on the guidelines on protection and security of internet personal information. So we have a general piece of legislation regulating the privacy rights of a person, more than the consumers. In the past, 2013, they concerned about the rights of the consumers, the rights of the community. Now they're moving, from the direction to the direction of protecting the rights, the personal data privacy right of individuals as a person. All right, so this is a change, I must say. And we have identified certain differences, major differences between the laws in the mainland of China and Hong Kong. You would be interested to see that there are two major, oh gosh, okay, differences. The first one being data localization. We don't have data localization in Hong Kong, but in the mainland of China, there is data localization, and especially for critical information infrastructures. Okay, so what it means, we can look up to various guidelines and measures published after the implementation of the law. The last slide will be a list of questions that we need to consider during the question time, okay, the developments about this interoperability and the importance of increasing convergence. So I will be prepared to answer questions that you may have. Thank you.
Thank you, Stephen. We now turn to Mr. John Cleason. John heads the Directorate of the Council of Europe, which includes within his responsibilities data protection as well as other information society aspects.
Thank you very much, Graham. Good morning, everyone. A few words perhaps about balance first. When I was asked to join this panel, I must admit I didn't realize it was going to be an all-male panel, so I apologize sitting here in this capacity. However, I hope you'll bear with me. Graham, thank you very much. Graham, thank you very much for pointing out to the moderate success of Convention 108 and for putting a very few specific questions on that. So I'll go straight into them. The second balance point is, in fact, geographical balance. The Council of Europe has the word Europe in it, but within the United Nations, it comprises more than one geographical area. We stretch from the Atlantic to the border of Alaska. A first point. Convention 108 brings together, you said moderate, and that is true, but it also depends whether you want to see the glass half empty or half full. At the moment, the committee that looks after this convention brings together about 70 countries, both as parties and as observers. Those are half the countries in the world that have data protection legislation at all. So that is an encouraging sign. Will we be able, was the question, to move beyond that, especially since our new convention, the modernized version, Convention 108, sets higher standards? I'm personally convinced it will. And I see two main reasons for this. The first, I think, is a greater awareness of the risk of data manipulation. The Cambridge Analytica scandal and other scandals that have appeared have, I think, raised awareness of what can happen with personal data. And I disagree with those who say that the younger generations have signed away their privacy rights. I don't think that's true. Second, new developments. It so happens that in the Council of Europe, I'm responsible also for the work we do on artificial intelligence. And I think artificial intelligence and other technologies are going to be a catalyst in this factor. Artificial intelligence for the good. Trusted artificial intelligence will require trusted and unbiased data. Therefore, for these systems to work properly, the exchange of trusted data and safeguards to ensure that what comes out of these applications will benefit society, these pressures will enormously increase. So there's going to be very much pressure on states, on state actors throughout the world to ensure that this is happening. And where there is sufficient political pressure, things may move very quickly. In the Council of Europe, following the terrorist attacks in France and other countries, we negotiated a binding treaty, a protocol on foreign terrorist fighters, within 7 weeks. It took us slightly longer, admittedly, to negotiate a 108, I-108 plus, particularly, and it has not yet entered into force. I hope this conference will persuade a large number of delegations that have already a ratification process to accelerate it, those that are still hesitating to look into it, and those that are skeptical to reassess really the advantages. I am convinced there will be convergence for this reason. I'm also convinced that, of course, the Council of Europe is, although larger than one geographical group, it's not the United Nations. But would it be realistic to expect a United Nations treaty on global standards on this within a reasonable time? I don't think so. So I would conclude with submitting that 108 plus is the best international instrument there is at the moment. Half of the states, as I said, that have data protection legislation are participating, and we would very much like to welcome all of you there in Strasbourg as soon as possible. Thank you very much.
Oh, thank you, John. And our last panelist, but not our last speaker on this panel, is Noboru Yamaji, who is the Commissioner of Japan's Data Protection Authority responsible for international cooperation.
Thank you for the introduction, Graham. It's a great pleasure as PPC to be invited as a panelist of this session. I believe that in regards to the theme of this panel, Global Convergence in Data Protection Law, that our Commission initiatives, international cooperation, have been exactly aiming towards promoting convergence and interoperability. That is why I would like to introduce to you people today some of our initiatives that we have taken today. Since the establishment of our Commission, which is in 2016, which is still quite young, we at the PPC have taken 2 initiatives, among others, in the field of international cooperation. One is mutual adequacy decisions between Japan and EU, as Bruno has mentioned earlier, resulting from convergence of our 2 legal systems. Another is the promotion of the APEC cross-border privacy rules system, the CBPR system, that may contribute to convergence or interoperability among legal systems in the Asia-Pacific region. Firstly, I would like to talk on the EU and Japan mutual adequacy finding, though I need to skip the details today because time is limited. Japan and EU have a comparatively similar framework for regulations on cross-border transfer of personal data, which can be categorized by 3 major transfer tools, which I can't explain to you today. But I think that the main reason for having such a similar framework is that both the EU and Japan have a common basis on the personal data protection, that is the OECD privacy guideline. Please look at the slides that is, I think, up at the moment. The left side is the 8th principle of the OECD privacy guidelines, and the center and the right sides are the list of the province that correspond to each principle of the OECD privacy guidelines on the GDPR and the IPPI, respectively. I suppose you can see that each has items corresponding to each principle. Now, with a view to mutually recognizing the other party as a country region that ensures an adequate level of protection of personal data, and also in order to realize mutual adequacy decision, Japan and the EU have had repeatedly dialogues, now counting 80 times since 2016. And as a result, finally in January 23rd this year, 2019, a framework for mutual transfer of data was constructed between Japan and EU. Now next, I would like to touch on the Asia-Pacific region. which you'll find that the legal system vary from country to country or region to region. Since each system is based, as Graham mentioned earlier, on various backgrounds, such as culture, history, and society. There are even some countries or regions that have established restrictions on the cross-border transfer of personal information from the viewpoint of ensuring necessary protection for the information of their own people. Now, the APIC CBPR system has been promoted and is in the developing stages, as been mentioned by Graham in the beginning, as a multilateral, multi-regional framework based on the concept of promoting cross-border transfer of personal information through appropriate protection of the information at the level of the corporations. The CPPR system is a mechanism to certify corporation conformity of the APIC privacy framework through assessment of companies' practice on the handling of personal information based on the CBPR program requirements. In the CBPR system, the accountability agent of each country authorized by the APIC carry out the certification and monitoring of these corporations. The privacy enforcement authority of each country, such as we in Japan as the PPC, carry out the enforcement to the accountability agent and the corporations. Now, one of the features of the CBPR system is that it's also based on OECD privacy guidelines. We at the PPC are promoting the CBPR system because we believe the system will contribute to rising standard of privacy protection at the level of each company, regardless of complicated levels of the region's countries. So I do believe that we are still in the developing stage, Graham, to answer your questions. And there are not only United States and Japan, but companies like Singapore who are also in involvement as well. We believe there will be some more as well in the years to come, months to come. But now I would like just to talk on this perspective that we at PPC with the colleagues in the United States EU have started discussion on new initiatives for pursuing a framework that ensures reliable, free data flow for the future. In such initiatives, we at PPC have proposed 3 ideas to stimulate this discussion. The first is to increase interoperability of existing bilateral framework. The second is to create certification system that is suitable for a wide range of countries and regions so the private sector can make best use of the certification system for proper handling of personal data. This second proposal aims to create a new system that can be applicable in a wider range of countries and regions than those currently exist. And the last, but not least, the third idea is to review the OECD privacy guideline, which are one of the global standards for personal information protection, so that is able to cope with present data risk that we have at the moment. Such risk will involve rapid development of AI, data localization, and unlimited government access. So in conclusion, I would like to say, Graham, that based on these initiatives, we at the PPC would like to work together with all of you and on the establishment of a global system that goes beyond the framework that exists at the moment with fellow countries like EU as well as US. And thank you very much today for listening.
Thank you. Well, I'd now like to invite up onto the stage our commentator, Mark Rotenberg. Mark is the Chief Executive Officer, as I mentioned before, of EPIC, the Electronic Privacy Information Centre based in Washington, DC, and which is one of the world's longest established privacy specialist NGOs. And Mark also represents the Public Voice Coalition of privacy advocacy organisations. Mark's going to give some comments from an NGO perspective.
Great. Thank you very much, Graham. Thank you to the organisers and the commissioners for the opportunity to speak with you. As Graham indicated, I am the Executive Director of EPIC. We also helped establish the Public Voice Coalition more than 25 years ago to organize events in conjunction with the annual meeting of the Data Protection Commissioners. We've held over 20 events, I think since 1993 in Sydney, and we're very pleased last year to put together the Universal Guidelines for Artificial Intelligence, the first framework for AI policy that addressed specifically human rights concerns and which was endorsed by more than 250 experts and 60 associations in 40 countries. The topic of this panel is convergence of global standards toward higher standards, and I'd like to begin by making a few comments on the three questions that Graham posed at the outset, looking at the three global frameworks that are likely very familiar to you. The first is that he noted the significance of the establishment of the GDPR, which many in civil society have supported and have worked to enact. But I think he also correctly pointed to one of the great challenges with this global framework, and that is the need for enforcement. So civil society is watching closely to see what steps will be taken under the GDPR to give meaning to this most critical legal framework. He mentioned next the modernized Council of Europe Convention, the so-called COE Convention Plus, incorporating very important new provisions on biometric identification and artificial intelligence. The challenge for this global framework, I would suggest, will be adoption. It needs to be ratified by more countries around the world to give it the global force that is intended. And finally, he described the OECD privacy guidelines, originally adopted in 1980 and some changes made in 2013. I think we should credit the OECD also with a new policy framework for artificial intelligence, which was adopted by the OECD earlier this year, but at the same time say, here as well, there is more work to be done. The challenge with the OECD principles, both for privacy and for artificial intelligence, is implementation. Enforcement, adoption, implementation. That is how we give meaning to global privacy frameworks. But I think there is more work still to do. I had the opportunity recently to read the manifesto that Giovanni Buttarelli had drafted, which will be soon published. It is titled Privacy 2030, A Vision for Europe. And in this manifesto, Giovanni reaches beyond the domain of data protection and looks at important questions concerning human rights and ethics, climate change, and sustainability. But one of the key points that comes across in the manifesto, at least to me, is a growing impatience with the debate and the discussion over data protection. He suggests, for example, that academic exercises are not taking us much further in establishing new privacy rights. And he also urges us to move forward quickly new privacy standards to address new privacy challenges. So in that spirit, I would like to propose to the conference for this panel two questions and also leave you with a declaration from civil society. The first question is this: will we stop technologies of mass surveillance, or will we simply rationalize their use? And the second question is this: will we allow surveillance capitalism to capture more of the information economy? Or will we establish rules to safeguard the dignity and the autonomy of the individual? These are central concerns of civil society, and in the Madrid Declaration of 2009, we made certain recommendations. We said specifically that it was time to have a moratorium on the deployment of facial recognition pending democratic debate and an independent assessment. And so I'd like to leave you today with the Declaration of Civil Society in the context of our discussion about global standards, higher standards, and how we assess progress with this request. And that is that you adopt a moratorium on facial recognition for mass surveillance. You assess whether the data collection that has occurred to date has been lawful. You undertake a study of the risks and biases associated with facial recognition technology. And finally, that you ensure that the legal rules, technical standards, and ethical guidelines are in place before this technology resumes. On behalf of civil society, thank you very much for the opportunity to speak with you.
Thank you. Thanks, Mark. Well, ladies and gentlemen, we have still approximately 20 minutes left, and we have some questions for the whole panel, which I hope can be put up on screen. Yes, they were flicking past there a minute ago. Just two more. That were back. Good. There. Thank you. Not on screen. Okay, good. Thank you. So we're just going to, while you all get your questions that you want to pose to the panel or panel members in your mind, we have a couple of questions here to the whole panel. And I think Noburu has volunteered to take the first of those questions, just for a very brief answer to the first of those questions.
Thank you, Graham. I think in terms of this question, our experience at PPC believe the word mutual understanding is the very, very key. It is conceivable that the key is to understand others in different jurisdictions and reach mutual understanding. We must note, as I was explaining in my presentation, that the level of data privacy is the flip side of disciplines, varies from country to country, region to region. And culturally, historically, and socially, background is different. So in the good experience of our, more or less, this kind of conventions through mutual adequacy decision between EU and Japan, the mutual understanding was the key that we were able to achieve this. Therefore, I'd just like to leave as my suggestion to you, Graham, that understanding and mutual trust and is a key that we must very much note. Thank you.
Good. Thanks, Noburu. Would anyone of our panelists like to take the second question? I would say I'm going to shift then after these three short answers to questions from members of the audience. Bruno.
Well, I volunteer for the second question because the answer is easy. We don't need any more convention. That we have all sorts of networks, we have legislation. That global privacy agreement exists. It's Convention 108 and Convention 108+. And why is it so important? I think there are two features of that convention that are important, apart of its universal nature. First, it's a really comprehensive convention that applies to the private as well as to the public sector. There's no sectoral exception. That's extremely important for the reason Mark just explained. There cannot be privacy legislation that applies only to, although it's of course important to the private sector for the reasons that I've mentioned, but also because data moves back and forth all the time between sectors and between the private and public sector, and also because that convention applies also to national security, to surveillance. And the second reason why this convention is extremely important, it's because of its focus on effective enforcement in terms of supervisory authority, in terms of redress, and in terms also of what I've briefly mentioned previously, in terms of cooperation between authorities. So now we have European, of course, countries that are party to that convention. We have African countries, we have Latin American countries. It's surprising to see, and I would like to take this opportunity, why, for instance, a number of Asia-Pacific countries, which are already observers, which have the legislation that should be already in line or largely in line with this convention, are not taking that step and are not acceding to that convention. And I hope that when we meet next year, we will have had good news also on that front.
Thank you, Bruno. Well, I'd like to ask, would any of our other panel members like to disagree with Bruno or add some further comments to what he has had to say?
Well, of course, thank Bruno for having for this position, which of course I 100% share. And if I may say one thing on question 1 and question 3, one sentence. The most effective thing we could do to ensure that standards are raised is perhaps not do anything for a moment, because something will go very badly wrong, and that will lead to enormous pressure. So we better get our act together. On the third question, and that links to what Bruno said, and also what Ken mentioned, it's adoption. Of course, 108 is a treaty. It would have to be ratified. But there is the possibility, as Bruno mentioned, to join as observers. We have a precedent for this. We have a cybercrime convention in the Council of Europe with 70 parties. But last year, we were active in 130 countries worldwide, because those that could not yet ratify have joined the community. And that is also something, perhaps, on this global standard, Convention 108, if you're not yet ready to join the convention as a treaty, you can join the community. You can join the committee that oversees its implementation and be part of the discussion.
Thanks, John. Yes, Stephen.
To make sure that the privacy is not a European obsession, I would like to share some of the comments in relation to question 2. Question 2 is a general statement about a global privacy agreement. I can agree with both of you that there might not be a need. There is no pressing need, especially, to have another global privacy agreement. But in relation to implementation and enforcement, okay, of the existing international agreement or global agreement, including GDPR, which has an extraterritorial effect to other jurisdictions, I think we need, something more than the existing agreement. For example, enforcement agreement, bilateral or multilateral ones. This is something that I believe, this conference is discussing about or working on, probably, for the next year or so, when we become, the GPA. I think this is one of the issues that we need to seriously consider, whether we need, enforcement agreement. Thank you.
Thank you. Jackie.
Merci, Président. Moi, je voudrais quand même dire quelques mots sur la première question qui m'interpelle énormément. Moi, je viens de l'université initialement, et on rêve à l'université. Et je pensais, jusqu'à ma prise de fonction, que la seule solution pour rehausser les niveaux de protection dans le monde concernant les droits humains d'une manière générale, c'était une convention internationale. Et je comprenais très très bien d'ailleurs la présentation de notre ami Kanatachi à la conférence d'Amsterdam, où son premier transparent était Superman. Et je ne sais pas, là c'est lui qui devra répondre, mais je pense qu'une convention internationale me paraît très difficile aujourd'hui concernant les normes ou pour rehausser les normes de protection. Et au cours de mes années de fonction ou de travail dans la protection, je me suis rendu compte qu'il y avait la solution. C'était la 108. Et j'ai fait que la Tunisie soit le 51e État à l'avoir ratifiée. Et aujourd'hui, la Convention 108 prend la place dans l'exposé des motifs et dans les textes qui sous-bassent ou qui fondent les normes nationales tunisiennes en matière de protection. Et j'ai fait le maximum pour que la Tunisie soit parmi les premiers à signer et, je l'espère bientôt, ratifier la 108+. Je pense que c'est là la solution. Mais il ne faut pas s'arrêter à ce niveau-là seulement, parce qu'un texte, même très beau, ne fait pas le printemps. Et avec les textes, il faut les moyens. Et pour rehausser le niveau de protection, il faut énormément de moyens matériels et surtout de moyens humains pour pouvoir avancer avec la protection. Voilà, c'est ce que je voulais dire pour répondre à la première question. Merci, Président.
Felipe, just before I come to you, I just want to say to everyone that the tablet I have in my hand here is where I'm supposed to find dozens of questions from the audience. But in order to do that, you need to download the conference app. And so this is a public service announcement for the benefit of all the subsequent sessions of the conference. Please download the app and send questions in. That's the way it's supposed to work. But I believe we do have we have now got a roving microphone, since no one seems to know about that for this first session. Is the microphone somewhere here? Yes, good. So I will take Felipe's brief comment first, and then I will hand over to our first question from the audience. Felipe. Okay.
About the second or the third? Second question.
Whichever you prefer.
Second.
Okay.
No, I agree with the companies of the panel. I think that a global agreement is possible, but I don't foresee it in the near future. Today, the most plausible way is to accede to the Convention 108 plus of the Council of Europe as the only pre-existent international document on that field. I think in my area it's possible another ways, but not in this moment. But this corresponds at the third question especially. In this moment, I think exactly the Company of Tunis sets first.
Thank you. We'll now take our first question. I think it is from Clarice Giraud, the director of the Privacy Project at the Asian Business Law Institute in Singapore.
And your female alibi. Hi, I'm also a board member of the Data Protection Authority of Jersey, so I have two hats. Some of you might know me. I'm a former regulator also with the French Data Protection Authority, so don't get me wrong. To me, privacy is a fundamental human right, and there's no going back on that. However, having been based in Asia for the last 5 years, I've also learned to sort of deconstruct my mindset slightly, working across 14 Asian jurisdictions and promoting solutions of convergence in that region with regulators and government. Now, certainly in Asia, like elsewhere, there is an aspiration to develop human-centric legislation. Might not go as far as human rights approach to data protection and privacy, or data privacy, whatever that means. The laws in that region are extremely diverse, more than anywhere else. The countries are very diverse. So the approach to data protection legislation are very different. So from Hong Kong, that takes human rights approach, fundamental right approach, to countries that have developed their laws much more recently to reap the benefits of the digital economy, because it's a consumer trust and trade issue. You have a wide range. Now, how do you ensure that convergence in that context, which is hard enough at the regional level, does not stay at the level of adopting laws that look alike and are basically copy-paste of GDPR or adapted GDPR provisions? How do you ensure that all the regulators, governments, civil society, when there are associations there, come and stay on board? And how do you ensure that cooperation and implementation is not limited to a lower common denominator, which is mutual recognition or technical cooperation and interoperability of data transfer mechanisms, and that would basically water down the level of protection globally? I'd like to hear your views on this.
Perhaps at the risk of repeating myself, but there is the instrument that also my colleague from the European Union, Bruno, kindly mentioned, 108 plus. I think there is, at the moment, there is one common standard. There are countries from all over the world that have already either joined or are in 108 and are interested in joining 108 plus. And I think that is at the moment the best bet to ensure that the cooperation and the convergence of standards that you mentioned is in fact implemented not only in Asia but throughout the world.
Unless any of the other panel, Mark?
I just wanted to pick up on the use of the term interoperable, because this actually strikes me as an odd word to use with regard to personal data. When we talk about interoperable, we're typically talking about systems and allowing systems to interconnect. But if we understand data protection as protecting a fundamental right, then that right exists in all contexts. And much of the determination, for example, under the GDPR, is understood to determine whether a data transfer is adequate or perhaps even essentially equivalent to the standard established under GDPR. So my caution on your question is that we use this word interoperable very precisely. We use it with regard to technology, but not with regard to personal data. I think that's a mistake.
Thanks. Okay. Just a brief comment, Bruno, because I want to see if I can get another question from the floor. Yes, Joe Kanatachi.
Yes, thank you, Graham. I'd just like to intervene very quickly on the second question you asked the panel. I tend to agree with all those people who have expressed themselves that when it comes to is there a need for an international instrument, I have, as the UN Special Rapporteur on Privacy, nailed my flag to the mast pretty clearly and publicly. One, it would be desirable to have a global instrument. Two, as pragmatists, we have to accept that there is no mood, no political mood amongst the countries for any form of binding agreement about most things. Thirdly, Convention 108, which is why I have publicly told the Human Rights Council, the General Assembly, listen, you guys are in no mood to agree to anything about most things. So I am going to go ahead and publicly recommend to everybody that there is a standard. It's a standard which has been developed over the past 40 years. It has self-developed into a de facto global standard. So let's not waste our time doing much else about it at this moment in time. What is needed, however, and which is what we've been trying to do in various ways to complement each other, is to respect the reality that the devil is in the detail. When Convention 108 was established, the Council of Europe didn't stop there. It came up with many sectoral recommendations in order to advise how to implement the letter and the spirit of Convention 108 in various places. So speaking for myself, and I conclude here, we have worked on, for example, the health data sector. Next Tuesday I will be presenting to the General Assembly quite a detailed set of guidelines on health data. We're working on privacy and children. We're working on privacy and gender in order to come out with detailed recommendations and safeguards in those areas too. We're also working on encryption. I will come out with more details about our work on encryption during the next few months. So there's a lot of detailed work going on. And what I'd like to suggest is that in order also to address what Clarissa has just said, when you take all of those together, you're creating a body of soft law and hard law, which people can respect when going about the practical dimensions of how to treat personal data. Thank you.
Thanks. One last question before morning tea from the back row in the middle here. Lady with her hand up. And then we will break for morning tea, and our session will have taken exactly its allocated time if we just keep this last bit short.
Hi, Graham. This is Pam Dixon, World Privacy Forum. Thank you. So just building on a couple of things. So on a panel yesterday moderated by Christian de Cunha in regards to a number of pressing issues, we learned that the data protection authorities in the Global South and elsewhere do not always get cooperation from the governments, even when there is law on the books. So I'm very interested in hearing from people from the data protection authorities in the Global South, in particular from the African countries and from also certain Asian countries, in regards to how this is working and what their implementation strategies are when there is very little government support. I think that's a very important topic to begin looking at, because we do have more laws in the books, but we don't necessarily have more implementation that is working throughout the government. And then just as a note, I would really like to see more women on the panels going forward. I would suggest Clarisse, who would have been fabulous, and I would also really like to see a variety of data protection authorities, particularly from the African countries, represented to answer some of these questions. Thank you very much.
Thank you, Pam. Well, I've been asked to wrap the session up, so we're just going to take some brief responses. Perhaps Chowki to start with, if you'd like to, about enforcement without significant government resources in Africa.
D'une manière assez rapide, j'aurais aimé effectivement que Marguerite soit là pour parler, ça aurait été une femme, et donc, mais bon, je vais parler en son nom, si elle le permet, et donc je fais partie du réseau africain, et donc je pourrais donner une idée générale sur la question. Je reviens de Dakar il y a quelques jours, et je ne sais pas si vous avez vu ça ou pas, je ne citerai pas le cas tunisien, et donc je suis beaucoup plus à l'aise pour parler du cas sénégalais, mais le chef de l'État sénégalais en est à son 3e conseil de ministres où il traite de la question de la protection des données. Et son dernier communiqué au cours du dernier conseil de ministres est très très clair sur la question. Il s'implique à 1000%. Et je pense que la situation ou le cas du Sénégal peut être transposé dans énormément de pays africains, dont le mien. C'est vrai que si mes amis de l'association francophone étaient à Tunis il y a 2 ans et ont eu l'occasion de voir personnellement le chef du gouvernement, et ils ont vu et mis le doigt sur l'implication personnelle des membres du gouvernement sur la question de la protection des données. Et donc c'est une question qui est à l'ordre du jour, et nos gouvernements sont très sensibilisés à ces questions-là, ce qui explique, comme je vous l'avais dit tout à l'heure, le pourquoi de la ratification de la Tunisie de la Convention 108 et d'avoir été parmi les premiers à signer la 108+. J'espère que ça répond à votre question. C'est vrai qu'il y a des problèmes de moyens, mais quel est l'État qui n'en a pas?
Thank you. Would any other panelists like to comment on Pam Dixon's question, or will we leave matters as they are? Well, I'd like you, ladies and gentlemen, to show your appreciation for our panel's excellent involvement this morning. Thank you.